Just the order is fully enforceable in any jurisdiction in the state upon receipt of notice that an order has been terminated under subsection 3 of the section. Yeah, law enforcement shall remove the order from the computer-based criminal intelligence information system. Now, this is Exhibit A. Yeah. The clerk of the court shall also forward a copy of this order on before the next judicial day to the Clallam County Sheriff's Office, which shall personally serve the respondent with a copy of this order, and shall promptly complete and return to this court proof of service. Yeah. Now, when you wrongfully execute a court order, okay, and then you serve somebody else, return of service. Yes, yes, yes. And there's a return of service. Yes. And there's not served, not served. Oh. These returns of service, not only did you wrongfully execute the court order, you gave it to somebody else that had no a rightful availability of being able to serve it. You served me in the Squim Public Library, and then for some fucking reason you think it's not contempt of court. Now, this whole idea of it being enforceable in every jurisdiction of the state, not only did you violate my civil rights in not giving me 5 judicial days notice before court hearings, you were enforcing it in Jefferson County. Poach happened to violate the Violence Against Women's Act because when you cross county lines, yes, and the sheriff's department themselves did not personally serve me as the respondent, yes, and they did not promptly complete and return to this court proof of service that they themselves personally served me, yes. It violates the VAWA because I can sue Jefferson County. See, I told you it's against the law. Now, I'm going to court on Friday, and you're sure that I'm going to Western State Hospital, but there's no way that anybody in this nation is going to enforce these laws. Now, this says here, relief, duration, or reliant designation of parties. Costs, service fees, attorney fees, and limited license legal technician fees. Yes. It says here in RCW 26.50.060, upon notice and after hearing, the court may provide relief as followed. See, you have the notice that happens first, yes, and then you have the hearing, yes, and then the court can provide relief. You can't have the hearing and then the court provides relief. It says upon notice, timely and proper. Exclude the respondent from dwelling that the parties share. Yeah. Committing acts of domestic violence. Well, if there's no upon notice, okay, and after the hearing, okay, you cannot award relief. That means that every time you issued a court order, both temporary and permanent protection orders, and there was no upon notice, and hearing, then you can award relief. Okay. Now, for every time you did that, it's a contempt of court, isn't it? Now, is there a conspiracy among those in the sheriff's department? The judiciary? You just don't. Well, is it the wheel conspiracy? Okay. Now let's say here consignment, contempt, console, consumer reports, contraband, contraception, contempt, TEMCOU, conditional they don't have it in here. No, see contempt. Maybe I'm spelling it wrong. Yes. They have an honors contract. Yes. Contract which each party is obligated to perform in exchange for the other's promise of performance. Yeah. Is this an actual contract of police and sheriff service? When it says you personally will serve me and you personally will have proof of service in the court file, is this a contractual obligation for the state to pay the sheriff to do that? Do you get paid? Now, is there a contractual obligation? Is there some money involved in this?